Apparently, they didn't think this case would be as exciting, huh?
I don't think, not to everybody else, maybe to my client.
That's right.
I'm Larry Hicks, Your Honors. I'm here to represent the employee, Joe Carroll Edwards, and I'm not going to go, of course, I'd like to reserve 5 minutes for rebuttal, but I'm not going to go into a lot of the facts because I know Your Honors have read the brief. Of course, this arose as a result of a very bad accident that occurred on August 14th of 2020 when my client was driving a truck and sustained very serious injuries to both knees. But in response to the court's request relative to the Beacon case, and I think really what that boils down to is whether the Workers' Comp Appeals Board followed the correct law in ruling that the trial court abused its discretion relative to the medical testimony. And I think that Judge Hensley, who wrote the a concurring opinion in that case, probably hit the nail on the head as far as what the law is in Tennessee. I don't think it's an abuse of discretion as far as which doctor the trial judge selects, but I think it's based upon the standard of preponderance of the evidence, and I think this honorable court is to hear the case de novo and decide where the preponderance of the evidence is, not just as to the trial court's findings on facts where he's heard witnesses and conclusions, but also as far as the medical proof, also if it's supported by preponderance of the evidence. The old rule of the abuse of discretion some way got carried over after the law was changed in 1985. Prior to that, even if the preponderance of the evidence was against a particular selection of a particular physician or doctor, the Supreme Court said, well, even if there's preponderance of the evidence is contrary, we still got to affirm the judgment. That's not true anymore, because now the court is to review it de novo. You're in as good a position as the trial court when it comes to reading depositions or documentary evidence. Of course, again, I think the law is clear that you would defer considerable deference to the trial court as far as findings of fact and conclusions. But when it comes to depositions, that would be de novo upon the record, and that'd be up. I mean, you'd have to look at the record in more depth than what the courts normally would under an abuse of discretion. That calls for more in-depth look at the record, and I want to get into that later. But as far as statutes or regulations, then that's de novo. There's no deference to the trial court's findings on those issues. Of course, the statute that we're dealing with primarily here is the statute that deals with causation and a presumption that's afforded a doctor's opinion on causation as far as in workers' comp, that there's a presumption of correctness, but that statute is 56-102-12E. It is conditioned upon the fact that that presumption is subject to rebuttal by preponderance of the evidence. I would respectfully submit to this court that the treating or the panel physician, he didn't actually do very much treating other than some injections, and then release my client after he said that she had pre-existing arthritic conditions in both knees, and it was his understanding of the law that an aggravation is not compensable under Tennessee law, which of course that's not true. And then the IME doctor of the defendant, Dr. Christian, he opined that Dr. Hutchison was wrong, that an aggravation can be compensable, but there has to be anatomic change. And I respectfully submit that that principle is not the law either. And the trial court noted that and found both of those opinions flawed. And I think that the trial judge, he didn't exclude the evidence, but I think it should go at least to the weight and credibility under Rule 703 of the Tennessee Rules of Evidence, where a doctor is basing, or any expert witness is basing their decision upon erroneous data. And that, in this case, the hinge-pin of Dr. Hutchison's opinion was he's not going any further with her, and he released her on September the 14th of 2020 on the first visit because he said that there was pre-existing arthritis and it was an aggravation, but it was his understanding of the law again that aggravation's not compensable. And Dr. Christian, he was of the opinion, as I stated, that if there's no anatomic change, then from his perspective, there's no aggravation at all. But the statute is clear relative to that if the aggravation is more than 50% related to the accident or incident, in this case a truck wreck, and the resulting disability and medical treatment is more than 50% related to that aggravation, which is a result of the incident, in this case the truck wreck, then it is compensable. And the only reason that Dr. Hutchison or Dr. Christian wouldn't say that it was more than 50% or it was compensable was because of their mistaken beliefs as far as Tennessee law. And Dr. Sweo, who was also on the panel, opined that it was more than 50%, both of her knee injuries, which he thought both needed surgery. Dr. Hutchison, all the doctors thought they needed surgery, which my client can barely walk.
So, Mr. Hicks, let me ask you a question about the record here, and that assuming there were anatomical changes that your client that occurred with your client that caused the need for the knee replacements, where's the explanation in the record, and what does that explanation say about why or how these anatomical changes caused the need for the knee replacements?
Well, there was anatomical changes for sure in the left knee, Your Honor. As you know, there was a fracture of the tibial fibula that was a 4 millimeter by 9 millimeter.
But what's the explanation for why that caused the need for
destabilization? Mm-hmm. He said that he testified that the ligaments that attached to that bone that was displaced, that was fractured, caused the knee to be destabilized. That was part of his explanation. And I think that there was more explanation even by Dr. Christian in that regard, that expanse of bone that was fractured, that ligaments slide through that, the top of the shin bone and the knee, that's where the ligaments are attached. But it's like Dr. Schrader testified, and really I think Dr. Sweo did a good job other than just the anatomical change, which apparently Dr. Christian wouldn't recognize, but he was clean. Well, he recognized he was there, but he said that wouldn't cause the need for the surgery. But in the record also, Your Honor, he says in the absence of arthritic change in the knee, which all the doctors agreed about the arthritic change. There was some disagreement as far as how much arthritic change. But the overwhelming proof in this case by all the doctors is that there was the aggravation and the trauma that resulted in the excruciating pain, disabling pain, and loss of function of the knees. Dr. Hutchison and Dr. Christian both testified that on August the 13th of 2014, assuming that Miss Edwards was asymptomatic, would she have needed knee surgery? And they said no. And then they went on to acknowledge in the medical records and their examination and the history that she was not experiencing any pain or symptoms, and that her surgery only become necessary by the necessity for the left and the right. Her private insurance got canceled by the employer before she could get a right knee fixed, and she doesn't have the money to fix that. But they said following the wreck, when she becomes symptomatic, and as Dr. Hutchison described it, after injections and therapy, it wouldn't calm down, and the condition was permanent, then the surgery bilaterally, both knees, becomes medically necessary after the development of these symptoms and excruciating pain from the wreck. So the record is overwhelming. And I respectfully disagree with the board. They made statements that in their findings that there was symptomatic problems with Miss Edwards before this wreck. I respectfully submit there is absolutely no evidence, as a trial judge pointed out, and as the dissenting opinion in this case pointed out by Judge Connors. Dr. Hutchison and Dr. Chris said, well, she was probably or more than likely having problems before this and just didn't realize it. It was like Judge Connor pointed out, that was just mere speculation and assumption. There was no evidence of that in the record. And then another thing that I thought was extremely important in this is where the appeals board was making findings that I thought were contrary to the proof, and I think that probably they were in error in their first order when they overruled the trial judge at the expedited hearing, that Dr. Sweo didn't give any explanation as far as how that destabilized the knee, and I think that he did talk about how it was destabilized and how the ligaments weren't attached. But regardless, it was the trauma and aggravation, as Dr. Schrader testified, that it made a condition that was asymptomatic. The intensity increased to the point that it needed more treatment, in this case knee surgery, in a condition that prior to this incident was asymptomatic. And
Mr. Hicks,
yes, I'm sorry.
I'd like to talk a bit about the about section 102.12c. This is the provision that requires a showing that it defines when an injury causes death, disablement, or the need for medical treatment. So
Right.
This is when it's been shown to a reasonable degree of medical certainty that it contributed more than 50% in causing the death, disablement, or need for medical treatment. What is your view on kind of how this, how the timing of the need for medical treatment plays into this? I mean, here we have a situation where, although your client was asymptomatic, at the time this accident occurred, she did have the underlying medical condition, and at least some of the medical testimony suggests that she probably eventually would have needed this surgery if things had just progressed according to the usual course of things. What seems to have happened with this accident is that it accelerated the need for the medical treatment. So maybe she would have needed it eventually because of this underlying condition, but the accident sort of accelerated the need. I mean, do you read this to, to allow for that? So that if it kind of causes the need at a different time, that is satisfying this requirement that it be greater than 50% of the cause.
Oh, I think it clearly is, Your Honor. I think that, like if you find that the trial judge was correct, and the board didn't address this, but he found that the plaintiff testified truthfully, credibly, and believed her, that she was asymptomatic. Even Dr. Hutchison and Dr. Christian both testified on August 13th she would not have needed this surgery. Following August the 14th, when her symptoms didn't calm down and it could be considered permanent, then in their opinion, she needed bilateral knee replacements, left and right knee. She only got the left knee up to this point. But I don't think it matters as far as when the medical treatment is necessary. It just made the medical treatment necessary, and it was more than 50% related to the injury she had in this wreck, which was a horrific wreck when her knees kept hitting the dash. Really bad wreck. But anyway,
I mean, what I'm having trouble with is that, you know, if she didn't have this underlying condition, and she had had the same accident, then, I mean, do we know whether she would have? I mean, it's just that these probabilities are very challenging, right? Because it's a little bit difficult to pinpoint.
I think you'd have to have a crystal ball, Your Honor, because it was like Dr. Hutchison testified, said she could very well be, with these knees, she could have very well been doing well and not have any trouble. Then on the other hand, he thought it might eventually lead to surgery. Of course, again, that was just a conjecture, possibility on his part. But what we do know is that pursuant to that statute, there's no question that the injuries from the wreck caused the injuries, that the injuries more than 50% the cause for her having to have the surgery and the disability and impairment she's got now. So I think the requirements of the statute are met, to answer your question, Your Honor. It's like Judge Connor pointed out in his dissent with the board decision. At the very least, it hastened the need for surgery. So that would fulfill the requirements of the statute. And of course, there's a preponderance of the evidence that supports that. And he agreed with the trial judge, and I think that obviously the trial judge is correct. But I'm not the only one. Judge Connor did too. And if you look at the statute, I'd respectfully submit, if you look at all the proof in this case in depth, that it would lead to the conclusion there definitely was a preponderance of the evidence. Here you've got a lady that's been a truck driver for 20 years, absolutely no problem. She can service her truck, drive, climb up in it. She does all the maintenance, routine maintenance, oil changes, and that sort of thing. And then after this wreck, even like Dr. Schrader pointed out at the emergency room down at the University of Mississippi, she was having difficulty walking. She said she could barely stand. And it was like Dr. Hutchison said, you know, somebody come in, they've got a condition, he'll give them an injection and try to treat it, and if it calms down, then that's great. If it don't, then he considers it permanent, and the appropriate and necessary treatment is a knee replacement. And exactly what he testified it happened in this case. The only reason that this case is where it's at, and I'm having to stand here and argue, is because Dr. Hutchison was of the opinion that an aggravation is not compensable, period. He didn't get into the 50% thing or anything. If it's just an aggravation, if you've got a pre-existing condition, it's not compensable.
He also had the understanding that her condition must have been symptomatic before the accident. So he had a factual understanding that's at odds with the employee's testimony, which was credited by the trial court.
That's it.
And then legal understanding that an aggravation was not compensable.
Exactly.
Okay.
That's the only reason that's the only reason I'm standing here, because that was his opinion. But and his assumption, Your Honor, is just that, as Judge Connor pointed out in his dissent. There was no evidence in the record of that, and my client denied that, and the judge found her credible, as Your Honor just pointed out. So I think the preponderance of the evidence clearly weighs in favor of reinstating the trial court's original judgment. And I submit to you that she met all the requirements as far as the medical expenses. We stipulated to those except the ramp, and the court excluded the ramp. But
So what do we do where the doctor testimony that you're relying on doesn't use magic language like contributed more than 50% to the need, things like that? He talks about it, caused it and so forth. What do we do with that?
Well, I don't think that they have to use, they're not lawyers, and I'm not saying that disrespectfully or arrogantly, but and I think there's some case law that says if they make statements that basically comports with the statutory language, that's sufficient because, they don't maybe have the legal expertise but actually in this particular case, Judge Kirby, that I did ask about the 50%, both to Dr. Sweo and Dr. Schrader, and they satisfied, as the trial court pointed out, those statutory requirements as far as causation being more than 50% as a result of the injuries.
Trying to remember their answers. I don't think that they definitely said yes, more than 50%. They more gave an explanatory answer that the accident caused the need and things like that.
Well, they did do that, of course, but then they did go into the more than 50%.
Okay.
The language is in there, Your Honor. As far as, and the trial court pointed that out, it's more, actually what they said was 51%. Instead of using, the 50%, the primary cause, anything greater than 50%, they talked about 51% greater than 50%.
That's pretty precise.
I don't know why 51, but they did. So.
It's more than 50. So.
It's at least 50, more than 50. I think maybe that was the point. But yeah, that language is in there, and there was some other language that's in there that is contrary to what the appeals board found. But it would take me too long to go in that. But the big thing is that Dr. Hutchison was wrong about a pre-existing condition or an aggravation, not being compensable, period. And then the anatomical change, Dr. Christian said in y'all's world, aggravation is synonymous with an anatomic change, no anatomic change, so there's no impairment at all. That's the reason there wasn't any impairment or restrictions given by them, because of misunderstanding of the law that the court pointed out. But I respectfully submit my client met her requirements under HIPIT as far as the temporary total disability, that her inability to work was because of the injuries from the accident and the duration of those accidents. Dr. Sweo had taken her off of work on September the 22nd of 2020, and there wasn't any other, her insurance was canceled. She had 5 visits with Dr. Sweo. He had planned to do the right knee replacement, but she didn't have the money to pay for it. The next mention, and the only mention of MMI, was Dr. Schrader on September the 14th of 2022. So the court calculated 104 weeks and 2 days of TTD at the stipulated rate that we had. And then as far as the medical bills, those were stipulated to, assuming found causation. And the only thing that the defendant relied upon and argued was that this wasn't related to the accident. And they say, well, she shouldn't have went and got medical treatment on her own without consulting with the employer. She did consult with the employer. She went by her employer, went doctor on September the 14th after she saw Dr. Hutchison. He said he wouldn't treat her under workers' comp. And then she got in touch with the insurance adjuster and told her about the MRIs of her knee and the fracture and the surgery that she needed. Dr. Hutchison told her she needed surgery, and Dr. Swell did too. Told her about Dr. Swell having a surgery scheduled for January the 11th. They got Dr. Hutchison to see her again on January the 4th of 2021. He still maintained his position that, it's not compensable. He even maintained that in the second deposition after it had been pointed out to him. He still maintained that. I think the court was right in substituting. I think that the judge has that authority. I wish I had that statute available. I've got it, but I don't have the number of it. the court can direct at the end of a compensation hearing the treatment that the person needs, and I think that they should have that right in this case especially, because Dr. Hutchinson is not going to do surgery on her knee under workers' comp. He's just not going to. And Dr. Sweo, she had to make that decision after she talked with her employer, and Dr. Sweo was on the same panel, so the doctor that she chose was on that panel, and she's kind of been treating with him, and I think that she should be allowed to stay with Dr. Swale. Apparently they have a good relationship. She has confidence in his ability to treat her. So in any event, I think that I would respectfully submit that the trial judge's order should be reinstated in all respects.
Thank you.
Mr. Hicks, let me ask you one question,
Yes,
if I
sir.
might, and I realize your time is up. I'll make this really quick. So, Dr. Hutchison, I'm assuming he gave his opinion within reasonable medical certainty that the aggravation was not caused by the surgery was not necessary because of the accident, right? I mean, didn't he give his opinion within reasonable medical certainty? And isn't the definition of that more than 50%?
I don't think he ever did that, Your Honor. And I tell you why he didn't. On his first visit, he said he was under the impression he had to give an opinion on causation, and he was adamant that that an aggravation is not compensable, period. It doesn't matter if it's 50%, less than 50% or more than 50%. His only argument was, well, at some point she would have probably needed the surgery, and she was probably having symptoms already. But then on the second deposition, he acknowledged that he was wrong in the first one. He had reviewed fast-paced records. She had no prior problems. The trial court found she had no prior problems. So he never did get into the reasonable degree of medical certainty, Your Honor, please, because he just wouldn't go that far. He just wasn't going to go there.
Okay, well, that's one way.
I tried to, but he did in a roundabout when I asked him about it. I said, well, would you have done surgery on August the 13th of 2020? He said no, and if she had no symptoms and no pain, and if she was functioning well, no. And I said, well, what about after August the 14th, when she developed all these symptoms and pains? And he admitted she developed them from the wreck. And so he says, well, that's what I was talking about the farmer. He said, well, after I injected her, and if she kept having these problems and all, then yeah, I think at that point the surgery becomes necessary. So if it becomes necessary at that point, even though it may not be the specific language of the statute, I think that would still imply that it was more than 50% caused by the accident.
All right, thank you, sir.
Thank you. Any other?
May it please the court. Stephen Morton from the Nashville Bar on behalf of Peoplease and Van Liner Insurance Company. I just wanted to touch briefly before I forget it, because I always write stuff down that I hear my opposing counsel say. The regulations and the medical fee schedule and the rules, and even the instruction when they give classes from the Bureau of Workers' Compensation to the physicians, they say that you're supposed to address causation if you can on the very first visit. Unless you need an MRI or something like that, you're supposed to do that. Surprisingly, Dr. Hutchison was one of those physicians that paid attention in class or to whatever he read, because that's why he gave his opinion on his first visit. But moving on, just briefly, I agree with my colleague on the standard of review. I think that it should be 50-6-225 de novo, and consistent with 50-6-225. I do not think it should be abuse of discretion, so we agree on that. But in this case, if you read the order from the appeals board, they sort of blend, and a lot of the orders have been blending it, saying we find that the preponderance of evidence supports A, B, or C, therefore they have abused their discretion. So in this case, you'll see preponderance of evidence. You'll see a blend of those, but there's also abuse of discretion, which the majority found that the lower court had abused its discretion and ruled in our favor. So that's a more stringent standard. And I wanted to go back to, this was a single automobile or 18-wheeler crash where the claimant was driving, her wheel blew out on the interstate. I think she bounced off of a bridge abutment and left the roadway and traveled down an embankment where she came to stop in a field. And I remember during trial, I asked her to explain the knees, and I was sitting at the council table, and I said, was it like this? And I bumped my knees up. So just to give you an idea of what happened, she said, yes, I was sitting like this, and my knees bumped up on the bottom of this Peterbilt trailer, which is the largest trailer on the road, and she was a restrained passenger. So at the emergency room, they had all their body parts checked out, as you would if you're in a motor vehicle accident. And the attending physician, with respect to the knees, they noted no swelling, no deformity, no signs of injury on either knee or leg. And the other findings from the neck x-ray, you have a head x-ray, basically head to toe they scan you. There was no acute findings. She was released that day. The one surprising thing or two surprising things she did find out that day were we just did x-rays, and you have bone-on-bone end-stage osteoarthritis of both knees, which is like the femur and the tibia actually touching each other. There's no more cartilage left. It's literally bone-on-bone. She was also told she's diabetic. So a couple of pieces of information. So following her release, she started treating for diabetes, and we provided a panel of physicians. We played this close to the vest. We got her a panel of orthopedic surgeons. She chose one, and it was Dr. Jason Hutchinson, who's a great knee and shoulder surgeon at Middle Tennessee Bone and Joint in Jackson, Tennessee. And I'm going to summarize, but after evaluating her on the first visit and performing x-rays, he stated unequivocally multiple times that his examination also revealed no cuts, bruises, or swelling consistent with that of the emergency room, that the cartilage in the both knees was completely gone, and while the accident exacerbated Miss Edwards' knee pain and symptoms, that her primary diagnosis of osteoarthritis was not caused or changed by the accident, which is important. He testified that the motor vehicle accident exacerbated the symptoms of her underlying osteoarthritis and resulting pain. He stated testified that the motor vehicle accident was not greater than 50% the cause of Miss Edwards' primary diagnosis, or resulted in any change of anatomical function in either knee. And finally, that even assuming Miss Edwards' arthritic condition had been asymptomatic prior to the motor vehicle accident, that total knee replacements would not be primarily necessitated greater than 50% from this accident. And that's an interesting question on that, because the statute now says that the disablement and the need for medical treatment have to be greater than 50% caused by the accident.
So if Dr. Hutchinson's opinion was premised on a factual understanding that she must have been symptomatic prior to the accident, and the trial court has credited the employee's testimony that she was not, isn't it based on a faulty premise in that situation? How do we accord it? How do we not say that whatever presumption would attach to his opinion is not rebutted if it's based on a factually incorrect?
That's a great question,
premise.
but I'll tell you what, when they asked, did she tell you she'd had any prior problems? He said, no, she said she didn't. They never said that they thought she was a liar. He didn't say anything like that. He said, no. He said she was asymptomatic before that, and maybe she was. But as a physician, who does this for a living and opens up knees that are end-stage osteoarthritis of all three compartments, that leads to, as in this case, meniscus tears. Basically, you're building a house and knocking out the legs of it when that cartilage is gone. So it causes meniscus tears. It causes edema. She had a bone tumor. It causes swelling that her treating surgeon even.
So it's your position that she's engaged in this accident where her knees are doing this all the way down a hill, and you're saying that that had no effect at all?
Oh, no, I'm not. I'm saying that it exacerbated her end-stage osteoarthritic condition that caused symptoms associated with that, pain, that would entitle her to a panel of physicians and medical treatment pursuant to 56102, which Dr. Hutchison gave her injections, he gave her the bracing, but under...
Was Dr. Hutchison under the impression that aggravation of a pre-existing condition by an accident like that was not compensable?
Well, the thing is we happen...
That's a yes or no, and then you can explain.
He stated that her primary diagnosis is osteoarthritis, and his understanding of the law, and this is before we got into it, is that symptoms associated with an increased pain of a pre-existing condition are not compensable under the Tennessee Workers' Comp.
So the answer is yes.
In a roundabout way, he said...
No, it's a yes or no question, counsel. Did he say it or did he not?
He said, I can't remember verbatim what he said, but he did make a statement about what he felt to be compensable and not compensable. And he was wrong, and we said he was wrong. So when we took the depositions, we deal with the doctors a lot, and a lot of them actually try to get into law. It's odd, but they do. I don't know if they fancy themselves part-time lawyers or wannabe lawyers or what, but they do it more often than you would think. What we have to do as lawyers is say, okay, calm down. You're not a lawyer. You're not an adjuster. You're not denying the claim. That's for the courts to do.
So if we have Dr. Hutchison's professional opinion based on an assumption that the employee must have been symptomatic before the accident, and his idea in his head that aggravation of a pre-existing condition is not compensable, how do we attach how is any statutory presumption not, how is that entitled to any kind of statutory?
Because 56102 on that section on the need for medical treatment has to be greater than 50% caused by the accident. It doesn't take into account if somebody's asymptomatic. It looks at this person's proposed treatment, which is a total knee replacement, and it asks the doctor to say, is the need for this total knee replacement greater than 50% caused by years of end-stage bone-on-bone resulting arthritis and this wreck?
But all of the physicians indicated that somebody can have an arthritic condition like that and be asymptomatic for many years. Are we going to interpret this statute that says, they might have needed that surgery by the time they were about 85 years old, so we can't hold that it's compensable if the accident presents so that they need it now? Is that the interpretation that you are putting forward?
I think that we have to ask the physician, do you think that this procedure that you ordered to put this bionic knee or this knee replacement in is greater than 50% caused by this wreck that she told you about, or is it because of the long-standing arthritis? You make the call, and then it's up for the court to pick which opinion. And this is sort of new, so we haven't dealt with this a lot when it comes to, I remember the medical director sent out a causation letter to all the doctors in 2013 that said, hey, everybody, this is the new law, and this is kind of what we're looking for when you see these patients that we want you to ask. And one of the hypotheticals was considering someone who has end-stage, arthritis in their knee, and they trip over something in the parking lot, is that trip greater than 50% the need of total knee replacement, or is it not? Those are the things you need to think about, and that was in that questionnaire.
Counsel,
But, I'm sorry, one quick question, but is there any evidence that Dr. Hutchinson reviewed that advice and relied on that? Or is that just something that went out and maybe you looked at it, maybe you didn't?
From his deposition testimony, they asked him, where are you getting this information? He said, from the literature I've read, from the classes, or from the classes from the Department of Labor. It's my understanding, the medical fee schedule, I'm supposed to address causation on the very first visit if I can.
so I'm trying to get a handle on exactly what you think 102.12c requires, what showing is required. Are you suggesting that it's almost a counterfactual inquiry? You know, you look at the patient and ask sort of whether this treatment would have been required in the absent, or what the probability would have been that this treatment would have been required if the pre-existing condition did not exist? I mean, is that how a doctor is supposed to determine whether something caused the need for, whether the injury was the cause of the need for treatment rather than the pre-existing condition?
It would appear so. That has to do with herniated disc in the neck. Does this one thing when you bend over, is that the straw that broke the camel's back that requires a multi-level fusion just when you bend over to pick up a piece of paper? Those are the questions that we have to ask the scientist and then obviously the court to interpret. But yes, the way I'm reading the statute is that for disability, meaning is, for example, if you look at someone and they have a 20% permanent disability, well, how much of it pre-existed? What disability is greater than 50% caused by this accident? If they say it's 10%, it's 10%. What medical treatment? Hey, we have a proposal for a fusion surgery. Is this fusion surgery greater than 50% causally related to the accident or made necessary from the accident? But that's about as far as I've gotten into it, to be honest, because
So where are you on the proof if we were to hold that whatever statutory presumption might have attached to Dr. Hutchinson's opinion has been rebutted? Where are you on the proof then?
my proof is like this. My proof is that when we went to the expedited hearing, we had Dr. Hutchinson's, and the expedited hearing order, it's really great as it sets out Hutchinson's testimony, Suio's testimony. And they, the appeals board overturned reversed the trial court and remanded it because we looked at Suio's testimony and Hutchinson's. Suio said, well, he never addressed what is the effect of this motor vehicle accident on the pre-existing arthritis and the need for medical treatment. You didn't address that. He said, for example, well, I think the right knee needs a knee replacement too. Well, are you going to get an MRI? He goes, we might get one, we might not, but I bet it shows the same thing as the left, and it's definitely going to be causally related to this accident. No matter what it shows, that's what she needs. That's almost verbatim what his testimony was. And even Judge Connor, who dissented in a footnote, says, I agree that at this time there was not enough evidence to support that a right knee replacement was greater than 50% necessitated from this accident with the proof as it exists today. That does not preclude that it might not exist someday, but it doesn't right now. So it was remanded. It was reversed and remanded. So the law of the case at that time was that Dr. Hutchinson was prevailing on this. Dr. Suio never addressed the aggravation. And that's the gravamen of this is what effect did the motor vehicle accident have on the underlying arthritis? Did it make it worse? Did it advance it? He was specifically asked in his deposition, what did this trauma do to the underlying arthritis? And he didn't answer it.
Okay, so let me see if I understand what you're saying. You're saying if we set aside Dr. Hutchinson's opinion as being adequately rebutted, so there's no statutory presumption attached to it, that the remaining expert testimony by Dr. Swio is still not sufficient to get the employee over the line of 50%, at least as to both knees, perhaps on the left knee, but not both.
That was his testimony for the expedited hearing. He was never redeposed, so his deposition has been reviewed by the appeals board and the trial court, and even the trial court.
By his, you mean Dr. Swio?
Dr. Swio's
Okay.
one deposition was produced for the expedited hearing and the compensation hearing. And even the trial court said, you know, the appeals board said that Dr. Swio's testimony didn't, you know, it was incomplete in this regard, but Dr. Schrader's isn't. Dr. Schrader did explain
Okay.
how this is. So Dr. Swio was never redeposed. I don't know why. I don't know what his position is on arthritis, and we'll never know.
And so Dr. Schrader's testimony?
So Dr. Schrader comes into the scene 2 years later. I also got an IME with Claiborne Christian, unaffiliated with Hutchinson, practices in Mississippi. He does an IME, and he says, I agree with Hutchinson all this. I've never deposed him before, but his opinions were parallel with Dr. Hutchinson's as to the effect of the accident on the arthritis. He says it wasn't aggravated, it wasn't advanced. He said by the time she did have to that she had her total knee replacement, the symptoms she was having were not from the motor vehicle accident, they were from underlying arthritis. He was very clear and succinct with his testimony. Dr. Schrader, excuse me, I'm gonna get a drink of water. Dr. Schrader was interesting because.
Wait until you get up to the microphone so that the live stream will pick you up.
Apologize. Dr. Schrader was interesting because he does an IME 2 years later, and all of a sudden, you know, that's the unique thing about the work comp law now. We try the same case twice, basically, at an expedited hearing, which is a full hearing, and then a compensation hearing. So when the compensation hearing came around, Dr. Schrader had done an IME, and he had assigned impairment to 7 different body parts when she had already testified that she had only injured her knees, her foot, and her sternum, and the trial court did not give her relief for the foot and the sternum because the proof wasn't there. But my focus was a knee case, and in comes 2 years later Dr. Schrader, who says, no, it's my neck, my left shoulder, my sternum, my pelvis, my foot. He rated, I think, 7 different body parts up to 30% to the body as a whole. And the trial court didn't accredit that testimony. They said that, Dr. Schrader, you prevail. You rebut the presumption of the treating physician because you address the aggravation questions. But we're only going to believe you on 2 out of the 7 injuries that you testified under oath were caused by this motor vehicle accident, resulted in permanent restrictions, and resulted in permanent impairment. It wasn't from countervailing proof that I presented. The court put in the order that we observed the plaintiff during the trial, and we didn't see any evidence of neck pain. She could sit fine. There was no neck thing. There was no overt behaviors. She was inconsistent.
Let me clarify something. I thought I understood that Dr. Schrader opined that the accident, more likely than not, aggravated the underlying condition.
That's correct.
Okay. I must have misunderstood.
Right.
I thought you said that he was
He did, in addition to.
consistent with that Schrader testified that the accident caused a fracture and a torn meniscus.
Correct.
Is that consistent with Dr. Hutchison?
No, it's.
Okay, I thought I understood you to say that Schrader was consistent with Dr. Hutchison, and I.
Claiborne Christian, my other expert
Gotcha,
was.
okay.
Now, I'm glad you brought that up because under the Orman test, when we're looking at weighing expert opinion, it's not a requirement, obviously, but it's certainly helpful. Dr. Schrader, out of all the 4 orthopedic knee surgeons in this case, Dr. Schrader is the only knee surgeon who does not regularly treat workers' comp patients, the only knee surgeon who does not think that she had tricompartmental osteoarthritis of both knees, the only testifying knee surgeon who disputes that she had end-stage osteoarthritis and is not even sure what that means. He's the only testifying knee surgeon who disputes that her knee arthritis had progressed to bone-on-bone contact at the time of the motor vehicle accident. The only testifying knee surgeon who believes that the motor vehicle accident permanently advanced her pre-existing osteoarthritis, causing the need for total knee replacements. And finally, the only testifying knee surgeon who believes that the motor vehicle accident caused a left meniscus tear. Even Dr. Swio, the surgeon, when we asked him about the meniscus tear, he said, oh, those go together like the chicken and the egg. If you have a degenerative arthritic knee, you're going to have meniscus tears. That's not related. So that is kind of where I'm having a problem with Dr. Schrader and the trial court accepting, well, we're going to believe you on the knees, but not on the other 5 body parts that you've testified to under oath. There was no anatomic impairment provided in the final order on what was rated. We know that the court found that, okay, we think your knees are compensable and you're permanently and totally disabled based on the restrictions from Dr. Schrader. But as the appeals board found, it was pretty much stipulated that Dr. Swio's testimony wasn't helpful. We've already looked at it. It doesn't address the main issues. Dr. Schrader, we're very confused on how you can cherry pick parts of an expert's testimony to believe them on, and her, by the way. She got up there at the compensation hearing, and my argument was, Judge, we were just here 2 years ago, and she sat there and testified for 2 hours. She didn't mention those other 5 body parts. Isn't that odd? And the court agreed and said, you know what, I'm just not believing her on those. There wasn't a credibility determination per se, but there wasn't an award for it, even though they had the medical expert proof, the impairment ratings. So that's
Mr.
where.
Morton, I want to talk a little bit about, kind of go back to your understanding of what this, 50% requirement shows or requires. I'm just having trouble, I think, imagining a situation where an aggravation, where when an accident, a work-related accident, causes an aggravation of a pre-existing injury, when that would satisfy that requirement, if your view is correct that it's like this counterfactual inquiry. So you kind of ask, well, would this medical treatment have been required had this underlying condition not existed? I took that to be your position in response to one of my earlier questions, that that's kind of how you would conduct this inquiry to determine whether it was the accident that caused the need for the treatment, or that primarily caused the need for the treatment, or whether the pre-existing condition caused the need.
The standard,
that you would ask, like, what would the probability have been that someone would have required this medical treatment in light of the accident if they didn't have the pre-existing condition?
I never really asked that because I really don't. For the purposes of what we deal with on a daily basis, the inquiries that we send to the doctors are from the statute that say, okay, this person had a prior back surgery in '94. They fell. Can you please answer these 2 questions? Do you think that this fall is greater than 50% responsible for aggravating the low back pain for which you are currently treating the person? Yes.
Well, see, that's a different question, right? I mean, the question you asked just now was, whether the accident caused the aggravation that has prompted the treatment.
Two-part question.
And that's a very different question, I think, from whether the accident was a greater than 50%, cause for the treatment. If you're looking at, if you're trying to determine whether it was the accident that was the primary cause or whether it was the pre-existing condition.
Right. I was just going through the
primary
statute
cause.
as it said. It's like an aggravation has got to be greater than 50% caused by the injury. The aggravation has to be greater than 50% caused by work and cause either disablement or medical treatment. And then it goes down there and it says medical treatment must be greater than 50%. Disability must be greater than 50%. So the subsections below the,
Okay,
once you've proven
sorry.
the aggravation, so let's
I
say.
cut you off too soon.
That's all right, I do
Keep
it
going.
all the time to people. I'm working on it.
Me too.
The low back example, I've got a low back thing. We say, doctor, the person fell, can you just answer this? Yeah, he fell. He's got a pre-existing issue. Do you think that the surgery you're wanting to do is greater than 50% necessitated from this fall in consideration of the 1990 fusion that he had at the level below? Yes or no? And that's what we all do now.
Would the term aggravation include acceleration of the need for treatment if you've got an underlying condition that eventually might have to result in surgery and the need for the surgery is accelerated? Wouldn't that fall within the meaning of a type of aggravation?
I think that's a great question. I saw you hinting to that earlier, and I was like, I hope she doesn't ask me that.
I just did, darn it.
Well, there is case law talking about it hastened the need. I think it's fact specific. I don't see hastened anywhere in the statute. I understand what you're saying. I don't.
Isn't that part of the common sense meaning of aggravation? It makes it worse right now.
I view aggravation, golly, so aggravation and exacerbation legally means completely different things as it does medically, which has gotten us into this position with the doctors in the first place. They say aggravations are permanent, exacerbations are temporary. We put aggravation and exacerbation in the same section as the same thing. So I view an aggravation as, ouch. It's, bending over and picking up the thing, my back, I raise up and it hurts tomorrow. It hurts the next day. I have to get medical treatment for it. That is an aggravation of a pre-existing condition that caused the need by greater than 50% of the doctor's visit I have, of the MRI, and of my time off work for temporary disability. That's what I view the aggravation. An aggravation could be temporary, an aggravation could be permanent. So our statute and our...
I'm hearing a yes, Your Honor, in there, but
talk a lot.
it's kind of
I'm doing the best I
meandering, but I think I'm detecting a yes, Your Honor.
We don't do this every day. I'm nervous. I talk a lot. Yes, Your Honor. I can't remember what the question was because
Well, go ahead.
I just have a question, Mr. Morton, and I hate to turn to the last page of the book, but I'm looking at this case. I see about 5 judges disagreeing with each other. You all agree that they applied the wrong standard on review. Both sides say they shouldn't have applied the abuse of discretion standard. You got a case that started with a doctor whose testimony was found to be flawed, and you've got 4 very well-paid experts all disagreeing with each other. So now I'm at the end of the book. What do you want us to do?
Well, I think that what I was going to say about the flawed thing, a doctor can say, I think the law is this, but then you drill down and say, doctor, what's the diagnosis? Do you think it's greater than 50%? Explain the scientific basis for your answer. He did it.
What do you want us to do?
I think that we need to affirm the appellate decision in this. The appeals board.
Even though you agree they applied the wrong standard.
Well, I prevailed under an abuse of discretion and a presumption standard. And the abuse of discretion standard is more stringent than what I think it should be. So I think that, there was a dissent, but...
Well, that does make some sense. If you prevailed under abuse of discretion standard, you should prevail under a lesser standard, correct?
Well, with my luck lately, who knows? I don't know.
All right, thank you,
I'd like to
counsel.
thank you again.
You reserved, I think, 5 minutes.
5 minutes. Yeah.
So, Mr. Hicks, what do you want us to do with
Your
all
Honor, I
this?
want you to reinstate the order of the trial judge of the trial court. And
Based on the flawed testimony of Dr. Hutchison.
Yeah, that's what it boils down to, because his 50% wasn't based on 50% of the aggravation. It was based totally. And in that letter that's set out in the brief, it was made an Exhibit 9 in the trial testimony, I believe it was 9. He says that since the underlying arthritis wasn't caused by the wreck, that it already existed, then he wouldn't attribute any aggravation, or it wasn't compensable because none of the arthritis was caused by the wreck. He acknowledged.
But
that
even
the-
if we set aside Dr. Hutchison's
Yes, ma'am.
testimony, we still have a conflict in the expert testimony, right? Because we have Dr. Christian,
I don't think you do.
no?
And I tell you why I don't. And this is, I think that this standard is even higher, the preponderance. The reason you don't is because Dr. Hutchison and Dr. Christian both testified that, in their opinion, even though she might have had problems, she was asymptomatic. She would not have required surgery on August the 13th. And that's the key to, I think, one of the big keys to this whole case. Both those doctors admitted she would, asymptomatic, would not have required surgery on August the 13th. Following the wreck on August the 14th, she became symptomatic. She had swelling, she had pain, and Dr. Hutchison even testified she had fluid inside her knees. No, both of them agreed with Dr. Schrader and Dr. Schweo that she would not have needed surgery on August 13th. They attributed the surgery being needed because of the symptoms that she developed following the wreck, where her knees continually hit the dash on August 14th, that were permanent, that after conservative treatment didn't get any better. And therefore, I respectfully submit that clearly Dr. Hutchison even rebutted his own presumption, because in the first deposition he said, I can't give an opinion to a reasonable degree of medical certainty, and I think you had asked that a while ago. That was because I did not ask for a history. Now, I don't think that's,
Well,
you know,
well, Mr. Hicks, what about the fact that,
so
that
he
Ms.
couldn't even say.
that Mr. Morton was talking about the IME that he had done, agreed with Dr. Hutchison? Doesn't that
He
create the
didn't agree
conflict?
with Dr. He disagreed. He said, I think you can't have an aggravation of a pre-existing condition. He said, the reason I don't think that you have an aggravation is because to have an aggravation, there has to be an anatomic change. I do not find any anatomic change, therefore there is no aggravation.
Was he looking at the same x-rays that had the broken leg in? Is that not an anatomic
I
change?
point that out. I thought, that oddly, he acknowledged that the broken bone was an anatomic change. But he still he disagrees with Dr. Sweo that aggravation can be compensable, but he says in this case it's not, because there's not an anatomical change and it's synonymous with aggravation, although there is a broken bone.
Okay, so you had this first hearing that was, I guess,
expedited.
advisory or whatever. however-
It was where we were asking for medical benefits to pay for surgery on her knee and on the right knee, and the court granted it and the board reversed it. And I think they said that Dr. Sweo didn't give a good explanation of why he time's out, but if I can finish, man.
Keep rolling. You
Hey.
got the yellow light.
Yeah.
He,
Just use caution.
he actually, I thought, did explain it pretty well when he said it destabilized the knee, and Dr. Hutchison agreed with that. He said if he meant by destabilizing it, it was asymptomatic before, and as a result of the injury, it became symptomatic and wasn't on that even plane anymore, and she developed pain and symptoms. Said I'd agree with that. And that's exactly what Dr. Sweo had testified in his first deposition. I'm out of time. Any other questions?
Any other
I'm
questions?
sorry about hollering. I guess I just get that way.
Nah,
Right?
that's
You're
all
allowed
right.
to get wound up.
I guess,
And sometimes, I guess, what this case teaches us is it's okay to disagree with yourself. Not necessarily you, but perhaps some of the witnesses in the case.
I think so.
I do that all the time. Thank you.
Thank you.
Thank you both for your very good arguments. We appreciate them. The court will take a short break.